Hello everyone, I welcome you back to our channel. This is Legal Mindset at the bar. So today we are in for contract law one of the major areas of emphasis, how to answer contract law one. In the house, you are with the right person, and this approach is to conquer, is to challenge the examiner. By the end of this session, I shall have given you an approach of how to enter a paper with 10 free marks with you in hand. It means if you're doing your paper out of 70, you have entered the paper when you have 10 and you're remaining with 60. So, what rules, what guidelines should you follow when the question paper is put before you? Passing is composed of a number of elements. We have preparation before the paper. We have preparation during the paper. Those are the two kinds we are going to look at. We are also going to see the examiner, the examinee, and the paper itself. You cannot pass your script when you do not know your examiner, and when you do not know the paper, and when you do not know yourself, you the examinee. Granville William, in his book, he said that a good lawyer is one who knows where to find the law, not the one who knows the law. And for purposes of education, I'm telling you, colleagues, a good student is one who knows their lecturer, not the one who crammed the law to their head. The trick is here. The paper is of 3 hours. If the paper is of 3 hours, your tactic, your way of approaching the paper is going to be the trick of passing it, not the work you crammed. To dive into it, I beg you to subscribe, turn on the notifications, because we are releasing a number of videos in such a kind which are going to help you succeed, which are going to help you score with high grades, even though you read, you never crammed. So let us start before the paper. And before the paper, we are going to look at the examiner and the examinee. Before the paper, you the examiner, you the examinee, you should be very keen of the words the examiner uses while in the lecture. I repeat it. Before the paper, take note of the words your lecturer uses, because your lecturer is your examiner. Not every case they talk about. Put them in your mind, research about them, because you're already discussing with the person who is going to set for you the exam, not their words. Then again, be composed of what the question carries. We are before the paper. If the question is contract law 1, what is the question all about? What does the question rotate around? And indeed, the question contract law 1 rotates around contract formation. What are the elements of a valid contract? If you know that, you're good to go. Because in contract law 1, you should master and put all the topics on your head, but not cramming. You should just know that we have offer, we have acceptance, we have invitation to treat, we have capacity to contract, intention to create legal bounds, terms of a contract, consideration. So, if we reach at the time of the paper, when you see the paper, you shall say that, this question comes from this topic. It will spare you from misfiring. It means put all the topics on your fingertips and put in your head that in contract law 1, we study contract formation. Since this video is purposely on how to answer, do not expect me to discuss for you any topic. If you want any topic, offer, and invitation to tweet, we recorded them. They are on our channel, Legal Mindset at the bar. Other topics, capacity to contract, Pino's case, doctrine of pivot of contract. Go back before watching this video of how to answer. Go and watch those videos, appreciate them, and come to this video before entering your exam, because it is of more importance. Every person who will use this video will come back after their exam and they shall say, thank you very much. And I'm waiting for that thank you indeed, because I'm going to give you 10 free marks to go with in your examination room. Now, I'm going to give you certain areas which cannot miss in a paper of contract law 1 at the end of this video. And if they miss out, come on my video and say those areas were not there. I know what I'm talking about. So, we have been before the paper and we have said before the paper, you should master all the topics and know that in consideration is where the promiser provides something of value to the promisee, and the promisee also gives something of value. You understand it. You know that in offer, the offerer makes the offeree accepts the offer. And the offer is that subject matter they are talking about. So, you go to capacity to contract, you say that we have the capacity of minors, the capacity of persons of unsound mind. You go to terms and representations. You differentiate terms from representations. So, that is before the paper. If you have any topic in contract law 1 you do not understand, search it and put Legal Mindset at the bar. That video will be brought to your attention and you shall appreciate it. I want all of you to pass your papers in a smart way, not in another way of cramming, because cram work is going to lead to make you misfire and earn poor grades. So that was before the paper. I emphasized you quoting the words of the examiner, knowing yourself. You should prepare very well. Don't spot before the paper. Don't spot. Read each and every topic. Now we are in the examination room. The paper is brought before you. What should you do first? So, for example, the paper has 7 numbers. The first and every step for every student who shall succeed on the paper and in life is a prayer of 1 to 2 minutes. Do not exceed that. Pray to God that He helps you to understand from that paper and to also answer that paper in a very good way. The examiner expects it. Here is a trick of the paper. The papers come to you. The examiner expects something from you. They expect you to write about something. But now I told you, on the paper, it's where the war begins. The script is before you. The script is for 3 hours. We do not want to know how many hours you used to read, how many extra steps you took to read. No. At that time, when you're on the paper, all of those are irrelevant. If you answer in such a bad way, you will be exonerated. You will be given poor grades. If the paper comes after your prayer, read the instructions for other 2 minutes. Highlight the compulsory number. Do not forget it. After highlighting the compulsory number, read it very well, because that is the gist of the paper. If you answer it very in a bad way, you're misfiring. You're killing the impression of the examiner. So, after getting the compulsory number, look in the rest of the 6 numbers or 7 numbers to get are the three numbers you're going to attempt. Here, choose the most easy questions. Highlight them. After highlighting them, read through them again. Start making your plan work on one page. The first page. Make your plan work. Say that this is consideration. I'm going to use Tudor versus Atkinson. I'm going to use Dunlop versus Selfridge. Say that I'm going to use the rule that consideration must move from the promisee. Put them down. If the topic is of acceptance, tell us that acceptance should be communicated to the offeree. Put down the rule. Tell us the case that Entowers versus Miles Far East Corporation. Put your plan work down. After putting your plan work down, cross out the plan work. Let me give you a trick. If you have been watching races, those people who start with energy, they rarely complete the races. Some of them collapse in the middle of the race. Others come behind. So, do not rush to start. Rushing to start does not determine your grades. What determines your grades is your plan work, is how you have planned for your paper. After laying down your plan work, start with the easiest number. I repeat it. Why do we start with the easiest number? Because when you start with the most easy number, you're going to impress the examiner. You're going to write correct things on your script. The examiner is going to be impressed. You know, these papers are marked out of impression. Have you written sense? So, what are the number of authorities you should put in each number? I urge you to put as many authorities as you may. And I urge you to go with an highlighter in your paper. You highlight every authority you use, because it is hard for the examiner to miss putting a tick at an authority you have wrote down on your paper. By highlighting them, we shall make it simple for the examiner to land on them, and it shall earn you good grades. So, we are on the paper. After doing that, you have started with the easiest number. Start telling the examiner that I started the contract law 1 and I know contract law 1. Tell him what is a contract. You are studying contract formation. Each number you see is under contract formation. Define a contract. What is a contractee? You can go extra miles to start with Article 40, Clause 2 of the 1995 Constitution. The Supreme Law of the land, which gives all people in Uganda the mandate to contract, the mandate to start their own businesses. After that, go to Section 1 of the Contract Act. Tell the examiner that according to Section 1 of the Contract Act, Cap 284, a contract is a legally enforceable agreement. Go on and tell him that under Section 9, subsection 1 of the Contract Act, Cap 284, a contract was defined in a better way as an agreement made with free consent of parties with capacity to contract for a lawful consideration, a lawful object, and with an intention to be legally bound. Go on to tell the examiner that that is my introduction. Let me give you my body. So, for example, the topic you're answering is consideration. Tell the examiner that Section 1 of the Contract Act, Cap 284, defines consideration. Define it. Under consideration, we see we have a promisor, a promisee, and the promise. Define the keywords in the topic. According to section 1, a promisor is the person who makes the terms of the offer. The promisee is the one who accepts them, and the promise is that offer made. Tell him that in section 19, an agreement made without consideration is void. You are building your AC in such a way that the examiner will also wonder, am I the one who taught this student? By doing that introduction, you have already gone to the paper with 2 marks, 3 marks for each number, depending on your examiner, depending on your lecturer. You will find some lecturers who shall give you 3 marks. You will find some lecturers who shall give you 2 marks, others will give you 4, depending on your lecturer. That's why I told you that a good student is one who knows their lecturer. Use the cases the lecturer gave you during the classwork. Now, go on. Put authorities in your essay. But when putting authorities in your essay on the paper, in your booklet, follow the ILAC of laws as I did. I started with Article 40. I came to the Contract Act. You can also put a case to follow the ILAC of laws. You can push the case of William Kasozi versus DFCU. And in that case, court laid down the elements of a valid contract. That is for the paper. A number, that is not a problem question. A straightforward question. You should answer it in that way. It means on each number we now have some marks, at least 2. Let us not be overambitious. We have 3 numbers. Remember, 1 number is a problem question. We have 4 numbers. We have 8 marks so far. Now, in the paper of Contract Law 1, it is very hard to miss a problem question. Now, how are we going to answer the problem question under Contract Law 1? We are going to answer our problem question on the paper under Contract Law 1 in this way. And if you have a pen, sit down, get a paper, and write down this approach. Because you're going to go with this approach on your paper. I know what I'm talking about. I studied the Contract Law 1. I know Contract Law 1. Start with the brief facts. Have you written brief facts? Do not write this now. This is an explanation. The brief facts must be brief. It means that pick the most relevant facts to rely on in your resolution. Pick the facts that connote with the topic of interest. So, for example, we are under the topic of offer. We are under the topic of acceptance. Let me use acceptance. Me and my friend here, Counsel Joshua, one of us is on one side of the river, and me, I'm at the other side of the river. That is how the question has come. They say Hamza is at one side of the river, and Counsel Joshua is at the other side of the river. When Hamza communicated his offer to Counsel Joshua, an aircraft passed. And Hamza is now urging that Counsel Joshua accepted. They tell you that advise Counsel Joshua. Let us move on that question. In our facts, do not write all those things we have said. Do not be overworded in your brief facts. If the facts are on 2 pages, put the brief facts on only 7 lines of a paragraph and write them in 1 paragraph, separating them with the full stops. So, our brief facts in the scenario I have just given you, we shall say that Hamza communicated his offer to Counsel Joshua at the side of the river, but when he communicated, for him is saying that is presuming that Counsel Joshua accepted. Now we go to issues. What issues are we going to use? Since you're studying contract formation, if you reach on a paper and you do not have any issue to use, I urge you to use the issue of whether there is a valid contract. Because you're studying contract formation, you're going to analyze, is there a valid contract? Where you said that you never had, was that acceptance? The scenario I talked about is under acceptance, and it is silence does not amount to acceptance. It means that if Counsel Joshua never replied, it did not amount to acceptance. So we go to the law applicable as our next step. Here, on the first law applicable, we are going to just list the laws we are going to use. We shall use the 1995 Constitution of the Republic of Uganda as a must, because it is the grand norm, it is the supreme law of the land. We shall go to the Contracts Act, Cap 284. We shall continue to case law. We shall use those theory, law applicable. But as per now, just list them as I have done. After, go to your resolution. Say resolution. And under your resolution, it's where you're going to earn marks. So, we have said brief facts, issues, law applicable. After putting law applicable, just list the laws you're going to use. 1995 Constitution, Contracts Act, case law. Then go to resolution. And in resolution, after writing the word resolution, start by Article 40, Clause 2 of the 1995 Constitution, and say that it provides that every person in Uganda has the right to practice his or her own profession and carry out any lawful occupation, trade or business. Continue to Section 1 of the Contracts Act, which defines a contract as an agreement made with free consent of parties. That is Section 1. Section 1 defines it as an agreement enforceable by law. Go to Section 9. Tell us that Section 9 defines it very well. A contract is an agreement made with free consent of parties with capacity to contract for a lawful object and a lawful consideration with an intention to be legally bound. So, after that, give us a case, William Kasozi versus DFCU. High Court Civil Suit, number 2326 of 2000, where court held that in order for the contract to be valid, we are studying contract formation, and if you lay down this case, you have gone extra miles to impress the examiner, because in William Kasozi versus DFCU, court held in order for the contract to be valid and enforceable, the following prerequisites must exist. The case of William Kasozi told us that you're studying contract formation. For a contract to be valid, the following must be in place: capacity to contract, intention to contract, legality of purpose, consensus ad idem, sufficiency, and sufficient certainty of terms. Do not forget the case of William Kasozi in your problem question, and when you're introducing any question. So, we have now seen, we started with brief facts, issues, law applicable. We are now on our resolution. I said on our resolution, we shall start with Article 40. We go to Section 1 of the Contract Act. We go to Section 9 of the Contract Act. We go to the case of William Kasozi versus DFCU. By giving that honoré, the examiner will give you 70 marks, depending on your examiner. Some will give 5, but most will give 7. If you add to the other 6 we add, it means you have 12 marks to 11 marks. You have entered the paper with the 10 marks assured. Now, we are going to introduce a formula to rely on in resolving. That formula is called PLEA. P-L-E-A. And PLEA stands for Principle, law applicable, explanation, analysis. And by doing this in PLIA, you shall tell us when you're resolving. For example, issue 1, whether there is a valid contract. Then the issue which fits our scenario of me and Counsel Joshua, where I was standing before a certain bank of River, he was standing at the other bank, and I communicated to him my offer, and an aircraft passed. Silence does not amount to acceptance. We shall say that whether there is acceptance of the offer. Now we shall come here in PLIA and we put that principal acceptance. After putting our principle that it is acceptance in our issue 1 resolution, we shall say resolution. After William Kasozi, we say issue 1, we put the issue that it is the issue of whether there is acceptance. We put under it our principle, it is acceptance. After putting that our principle is acceptance, we shall define what is acceptance. Define acceptance by any authority you know. After defining it, tell us that in the above scenario, there is the general rule in there is a rule in acceptance that acceptance must be communicated to the offerer. So, after the principle, give us the law applicable. What is the law applicable there? If you have any provision of the Contract Act, put it, which governs acceptance. And indeed, if you go to the Contract Act, the provisions are there that acceptance should be communicated. Go on and bring in the case of ENTOWAS on acceptance should be communicated. All silence does not amount to acceptance. All those rules work on this scenario. If you put, you tell us that in the case of ENTOWAS versus Miles Far East Corporation, Lord Denning held that silence does not amount to acceptance. Acceptance should be communicated effectively to the offerer. So, that is your law applicable. You have put a section in the Contract Act, you have put a case. After you go to the explanation. Now what is the gist of the explanation? In the explanation, I want you to marry the law with the facts. Tell us that according to the above scenario in the facts, Counsel Joshua cannot claim, cannot successfully sue for acceptance because silence does not amount to acceptance, as laid down by Lord Denning in the case of ENTOWAS versus Miles Far East Corporation. That is how you can put it for the explanation. You marry the law with the facts. Now, go on to the analysis. In the analysis, remember they told you, advise Counsel Joshua. In your analysis, tell the examiner that in advice of Counsel Joshua, do not wiseacre. Do not advise the party they didn't tell you to advise. Tell the examiner that in advice of Counsel Joshua, silence does not amount to acceptance. So, Counsel Joshua cannot have a successful claim in court if he enforces the contract. That is your analysis. Tell us on which case have you relied. The analysis are your own words, but start with the words. Keep on looking to the question. Look at the words the examiner used. Use those words. By using them, you're impressing the examiner. If you have another principle, put it. Maybe another principle is about display of goods, and the contract. The issue is whether the display of goods is an offer or an invitation to treat. Tell us that the principle is display of goods. Tell us display of goods is an invitation to treat and not an offer to sell. Come on our law applicable. Clear, we have finished principle. It is display of goods. You have talked about display of goods somehow. You have given us an authority. Come to the law applicable. Tell us that in the case of Fisher versus Bell, court held that the display of a knife is an invitation to treat and not an offer to sell. give the facts of that case. I'm not going to give you those facts to you. This is a video on how to answer. So, come to the case of Pharmaceutical Society of Great Britain versus Boots Kashi chemists, as on our law applicable. Tell us that in this case, court held that the display of goods in the shelves was an invitation to treat and not an offer to sell. But first bring in the facts of the case, something like 2 lines. So, after, give us the explanation, marry the facts with the law. Tell us that when Counsel Joshua went to the supermarket to buy sugar, when he picked the sugar from the shelves, that was an invitation to treat. Though there was a price tag, it was an invitation to treat and not an offer to sell. In your analysis, tell us that in advice the person, the question is urging you to advise. Don't be a wiseacre. If they tell you to advise the parties, advise all the parties accordingly. That is how you're going to answer our problem question. Remember, we have law applicable 2 times. In the first law applicable, after brief facts, issues, law applicable, just list the laws you're going to use: Constitution, Contracts Act, case law. But when you come in resolution, after putting in the Article 40, Section 1, Section 9 of Contract Act, William Kassozi versus DFCU as a must resolve, and after the principle, the law applicable, just now bring in the exact law. Don't just highlight it, don't just list it, bring in the exact law. For example, you can quote Carril versus Carbolic Smoke Bowl. And remember, in the first law applicable, we said case law. We never quoted any case. In the second, quote a specific case, quote a certain provision of a statute. That is for the problem question. After analyzing all your principles, analyzing all your issues, do not use an issue you're not going to resolve. Do not use a law applicable you're not going to use, but use the Constitution, and on the Constitution I have given you Article 40. So, that is it for the problem question. After analyzing all issues and all the principles, conclude. In conclusion, therefore, contract law is based on a number of principles for there to be a valid contract. Then start talking about the parties and conclude. Then that is how we shall answer our problem question. Use a minimum of 35 minutes to answer every question. But for the problem question, I've told you, you're going with 7 free marks. The structured ones, you're going with 2 to 3 free marks according to your lecturer. It means if you have watched this video from the start to the end, you have certainly free marks. I urge you to forward this video to your colleagues. Do not be mean. Let us share knowledge. Let us appreciate the law together. If you know any colleague at Makerere University, at Nkumba University, Kampala International University, IUIU, forward this video to them such that they excel in contract law 1. I told you, when you're answering a question of contract law 1, rely on the fact that in contract law 1, we are on contract formation. So, in the end, do not forget to read these topics: offer, invitation to treat, acceptance, consideration, Pinno's case, doctrine of privity of contract, capacity to contract, intention to be legally bound, terms of a contract. Some people are saying you have talked to them all. Read everything. Thank you very much. This is Legal Mindset at the bar. Subscribe, turn on the notifications. We are releasing many videos which are going to help you pass your exams with good grades. Thank you very much.